gave a response about the May 12th meeting.
You had received the May 12th report, correct?
I had certainly received it at that point, but what this is referring to, we received the reports which he has received, and talks about how we would likely use that. We didn't receive any reports until the May 12th meeting.
And they were in fact asking you about the April 10th meeting, which is the meeting that you now say was the one where you actually got all the unidentified male DNA results from Dr. Meehan, correct?
Yes, sir, but when I was referring to the report, I was referring to the written report, which was received on May the 12th.
I understand that, but the defendants were asking you in court about a meeting on April 10th, which you now say is the meeting at which you got this unidentified male DNA, correct?
It appears that's what they were asking about. It does not appear that's what I was answering about.
Well, certainly you would agree that the comments you made at June 22nd were misleading, at least, if you're referencing a meeting on May 12th and talking about it being on April 10th.
I don't deny that that would have been misleading, sir, but it certainly was not my intent. I obviously misspoke, but my answer makes it clear to me that I was referring to the May 12th meeting.
Okay, and you represent that there was nothing to provide that wasn't an attorney work product beyond what was in the report?
Yes, sir, that was my representation.
And again, your contention is that you never went back prior to that hearing, despite being on notice, and read the report?
Yes, sir, that's true. If I could say something, Mr. Brocker, with respect to that generally. As somebody who, for all my career, has given open file discovery, maybe I take a little bit of a different view towards things. I know that there are people who read documents and things that they receive looking for reasons not to give them, or there used to be. But I've never looked at it that way. My assumption is that if I get it, I'm going to give it, and I don't make exceptions, and I don't. So I'm not looking over stuff maybe as attentively as some people would, because I'm just going to automatically be giving what I get. That's just always been my policy, and it may have worked to my disadvantage in this case.
Now,
but
when you receive, I'm sorry. Go ahead.
That's all right, Your Honor.
So when you received that May 12th report, two of the players had already been indicted, right?
Yes, sir, that's true.
And you didn't think it was important to go through the report and make sure that the exculpatory information that you had been told was actually in the report?
I knew that there was nothing, no inculpatory information regarding either of those two players in the report, and that's probably all I was thinking about in terms of that. But I did not go through the report.
So even though these two young men had been indicted, the only thing that you were thinking about was whether it was inculpatory or not whether that there was exculpatory information that should be disclosed in this report.
Well, in the first place, I think that it is specifically exculpatory to give somebody a report that says we tested all these items from the rape kit and found no DNA from either of these two players or any of the other players on any of these items. I think that is exculpatory. I think that's specifically exculpatory.
But it's also,
and that was provided. So it's not, I don't think it's fair to say that I was not trying to give them arguably exculpatory information when I gave them specifically exculpatory information.
Well, actually, the report itself doesn't say anything specific about the fact that they don't match. You have to imply that, correct? Unlike, for example, the SBI reports, which come out specifically and say, we found DNA and it didn't match, this report said nothing about that, correct?
I believe that it, in fact, did not say anything about that specifically.
Now, this issue came up yet again at the September 22nd hearing, correct?
Yes, sir.
And again, you were put on notice in advance by the defendants that this issue was going to come up.
I don't recall the specific motion. I guess that'd be the joint omnibus motion. Would that be the one you're referring to?
That's correct. And
yes,
we
sir,
talked about that earlier.
Yes,
in
sir.
the specific request for the meetings of Dr. Meehan in that.
Yes, sir.
They brought it up again.
Yes, sir.
And they specifically asked again for exculpatory information. If you look at 223,
yes,
page
sir.
8. Sorry, page 7.
Yes, sir.
And that's the request for information about the meetings with Dr. Meehan, correct?
Yes, sir.
And at the very next page, very bottom, they're asking for information of a number of things, and they specifically cite Brady and exculpatory evidence in that request.
What are you referring to, sir?
It's the very last sentence on page 8 of that paragraph.
Oh, yes, sir, that paragraph. Yes, sir.
And they specifically, again, mention exculpatory information.
Yes, sir, they did.
And those were taken up at the hearing on the 22nd.
Yes, sir, I believe they were.
And you responded to a question from Judge Smith, and in direct response, you represented that there were no other statements made to you beyond what was in the report of DNA security.
I believe that's correct. I don't have the specific reference, but I think that is correct, sir.
All right. Well, you can go to Exhibit 224, page 28. Sorry.
Yes, sir.
The transcript is actually 225.
Yes, sir. It says, that is correct. The facts of the case, other than the fact that we were seeking a male fraction DNA, the facts of the case weren't discussed in those meetings.
Right. And before that, going back to page 27, the court asked you at the very bottom there on page 24, so his report encompasses it all, correct?
Yes, sir.
And then you give an answer, and Judge Smith comes back, line 10. So you represent there are no other statements from Dr. Meehan, and your response is no other statements made to me.
Yes,
correct?
sir. That's
and then
correct.
Mr. Bannon follows that up to make sure it's clear. Just so I'm clear, Mr. Nifong is representing that the facts of this case weren't discussed in those meetings with Dr. Meehan, correct?
Yes, sir.
And your answer was that's correct. And again, you contend that before making this affirmative misrepresentation to the court, you contend you never went back and read the report to find out whether that potentially exculpatory information was in the report, correct?
That is correct, yes, sir.
And the court, in fact, relied upon those representations in entering its order denying the defendant's request to get the content of those meetings.
I think that's correct, sir.
And about a month later, Mr. Bannon sent you an order, which we've already discussed here today, which said precisely what we just talked about, that you had represented that there was nothing else discussed beyond what was in that meeting, and that the court relied upon that in denying the request. Do you recall that?
I recall discussing the order. I don't recall the specific language of that section of the order, but I don't deny that. I mean, I'm sure if you're asking me that, it must be there.
And you would have had yet another opportunity before consenting to that order to go back and read the report and see if the information was in there.
I certainly would have had the opportunity, yes, sir. I did not take it.
And during that hearing, you mentioned in response to the chair's question that you had made a comment about the other information that was requested, the underlying data, that it was a witch hunt, the defendant's witch hunt.
Yes, sir, I did.
And that witch hunt, in fact, is what led to the discovery of the exculpatory information in this case.
Yes, sir. It did lead to that, although there was no question that they were entitled to it. As indicated, that wasn't an objection to their asking for it. That was just my way of getting a statement in front of the press that was contrasting some of the public comments that the defense attorneys had made about the strength of the DNA case or the DNA evidence with what they were saying in court. And I've admitted that statement.
In fact, that
Statement on September 22nd was a false statement of material fact to the court, correct?
A false statement of
false
material
statement of
fact.
material fact that you made to the court.
I'm not sure that I agree with that. I don't understand.
Okay?
Hold on. Outlines which one of the couple statements he was talking about refers to.
I'll clarify.
You want, all right.
The statement you made to the court on page 28 of Exhibit 25.
28 of Exhibit 25?
225. 225.
Oh, I thought you were asking about the statement about the witch hunt. When you asked that question, I thought you were asking the second.
No, I'm sorry.
Okay, all right. That's what confused me. Yes, sir.
All right. The statement that you made to the court that we read before, that where Judge Smith asked you if you represented that there was no other statements from Dr. Meehan, and you said no other statements made to me. That is a false statement of material fact to the court, is it not?
As I said before, it is a false statement that was made unintentionally. It was unintentionally false. It represented what I believed to be true at the time.
And you would agree that it's a false statement of material fact if, in fact, it's directly responsive to the court's question?
Yes, sir. I'm not agree with that.